Exercise has been part of my life, my whole life, since I was in middle school. So I went to the gym probably 5-6 times a week. That day I was exercising after work, and about 10 or 15 minutes in, I had the biggest headache. I actually thought the trainer hit me over the head with a 2x4 or something. I ended up calling my brother who lived down the street, called telehealth, and then telehealth said you should come right away. And then I was in ICU for 5 days and diagnosed with a subarachnoid hemorrhage.
Sara Baker was 38 years old. She suffered a stroke while she was exercising. She was at that time employed at Humber River Regional Hospital. She was unable to return to work, so she made a claim to her own insurance company for disability benefits.
Well, I applied for short-term disability, and then just as that ran out, then I applied for long-term. The insurance company agreed that I couldn't do my own job, but they didn't agree that I couldn't do any job.
When her claim was denied, she contacted us at Thomson Rogers to pursue a lawsuit on her behalf.
It was right before discovery that they started surveillance.
Blue Cross conducted over 350 hours of surveillance, much of which was played at trial.
Surveillance was a horrible part of the whole journey and the process. We would do weekly Zoom calls with Stephen mostly, and then as we got closer to trial, he would pull in other people. Lucy came on board, and Rob. I was talking to them every day and just going over questions that I was going to be asked and preparing me for cross-examination.
The case went to trial in 2022 before a jury in Toronto. In my closing argument at trial, I argued there were at least 14 different areas in which Blue Cross demonstrated bad faith, including its excessive use of surveillance, its distortion of its own medical opinions, and its neglect in considering the opinions of Sara Baker's doctors. The jury found that Sara was totally disabled and that Blue Cross had acted in bad faith in handling her insurance claim, and ordered that the insurance company pay $1.5 million as a penalty for its bad faith.
I had no idea in my mind that there was going to be any punitive damages like what was awarded. I just wanted to win and not be stuck with huge legal fees. I don't know, I think I kind of was in shock. And yeah, it didn't really hit me until we got into the room afterwards, and then Stephen and Rob said the highest in Canada.
Blue Cross appealed the jury's finding that it had acted in bad faith, as well as the jury's finding that it should pay $1.5 million as a penalty. The Ontario Court of Appeal denied Blue Cross's appeal, found that Blue Cross did act in bad faith, and that the $1.5 million penalty was required in order to deter Blue Cross from acting in a similar manner against other people. Damages for bad faith cannot be token or nominal amounts. They need to be significant and meaningful in order to deter insurance companies from improperly denying claims in the future.
It did feel quite empowering. It felt quite a bit surreal to be at that point and to realize it was over, and then the impact on the industry. Hopefully there's been some change, and maybe even just one headache patient gets less of a hard time. That would be a huge win for me, because I wouldn't want anybody to go through what I went through.
Sara had the courage, the fortitude, and the stamina to take her case all the way to trial. Many people don't have that ability, and in doing so, what Sara has done will help others in the future.